Thank you everybody for coming. We have a great webinar today, and I'm just going to do a brief introduction before I hand it over to the team. So I'm Kimball Parker. I'm the CEO of SixFifty. And for those of you who are joining us for the first time or hearing about SixFifty for the first time, we're the technology arm of the law firm Wilson Sonsini. And in the technology space, Wilson Sonsini is like the New York Yankees of law firms. They helped found Apple and brought them public. Same with Google and Twitter and Lyft and Tesla and SpaceX. And so we work with the firm to create automated legal products. And so the idea really is to bring down the price so that you don't have to be Apple or Google to afford Wilson Sonsini's legal expertise. So we have a really great job. We build products for businesses who need legal help. And we also build products for people who need legal help. And during the pandemic, we helped over 16,000 people at risk of losing their homes during COVID, all for free with an automated tool called hellolandlord.org. But today, we're not going to be talking about that. We're going to be talking about privacy and operationalizing your California privacy compliance. And we have some interesting experience in this area that I'm going to give you just a little background on. Wilson Sonsini has some of the best privacy experts in the nation and in the world. So they have a big office out based in DC where they have incredible privacy expertise. Some of the top experts who used to work for the government, the former head of the FTC, the Federal Trade Commission, and then they have a big office in Brussels, which focuses almost exclusively on privacy with the GDPR. And so a lot of the firm's clients have struggled to figure out how to comply with this new wave of privacy laws. And so about a year and a half ago or 2 years ago, we worked with Wilson Sonsini to build an automated compliance tool for the CCPA and the GDPR. And so it contains all the legal documents you need, all automated, like TurboTax, the training you need, data mapping, and a system to collect and respond to data access requests. And so building this was a huge project. And we've helped hundreds of organizations comply with those laws so far. And so anyway, I'm telling you this because you're going to hear from two of the main people who, well, I guess one of the main people who built that tool, and the other person is the main person who helps people use the tool. So first, you're going to hear from Marie Colbeth. She graduated near the top of her class from one of the best law schools in the nation. She clerked for a federal circuit court judge in the South, in the Fifth Circuit, which is a very prestigious thing to do in the law. She worked in private practice and was taught at BYU Law School. And we poached Marie away from BYU, and it was one of the best decisions we've ever made. It's not an exaggeration to say that Marie is one of the top privacy experts in this country. And so be prepared to be impressed by Marie. Second, we have Mark Higginson. Mark is the vice president of our customer success team, and his team helps onboard all the companies onto our platform. Mark is really where the rubber hits the road for companies. And he's helped hundreds of companies get compliant with these laws. Mark brings with him over a decade of sales and customer success experience. And before coming here, he was the global director of customer success at WeWork before we poached him away. So we're very lucky to have Mark on the team. He's great. He's funny, as you'll see, and he's wonderful. So 2 plugs, and then we'll be off to the races. If you want to learn more about our privacy compliance tools, and specifically for the CCPA, you can visit our website at sixfifty.com/CCPA, and we will put that in the chat. So sixfifty.com/CCPA. And that'll take you to a place where you can learn more about the product and sign up for a demo if you want. Obviously, no pressure to do that, but in case you need help. Second is that if you have any questions, please put that into the Q&A option below and not into the chat. So, if you ask a question in the chat, it's fine. It's not a huge deal, but the Q&A function is nice. We can answer those and catalog them and track them and then actually send them out after the webinar. So if you could put your questions into the Q&A, that would be great. So without further ado, Marie Colbeth, Esquire, and Mark Higginson, VP. Go ahead.
Thanks, Kimball. I noticed that you didn't say I was funny, but I guess that's expected since I do
you're funny too,
law.
Marie. You're funny too. It's
you don't have to fake it.
Your
it's all law
dwarfs your humor, Marie.
It's all law humor.
The best kind.
Yeah.
And I also want to say we also have joining us today Austin Smith, who's a member of my team over on the legal development side at SixFifty. Austin's another privacy law expert, and he's going to be helping me during a couple of slides and also in our Q&A portion today. So with that in mind, I will also mention, just here's your privacy note, we're recording this webinar so that we can share it afterwards. So if you do put in a question and you want to put yourself in as anonymous user, you're welcome to do that. Otherwise, your name will show up for other attendees. So that's up to you. With that, let's turn to today's topic. Today, we're talking about operationalizing your privacy program. Specifically, sorry, did you guys all just lose the screen share?
I can see a white stripe down the middle.
Something weird just happened. 1 second, I apologize. Let me start again. How about now?
Looks great. Operationalizing your California Consumer Privacy Program looks clean and clear.
Okay, sorry about that, everybody. Okay, so, and again, another disclaimer, because I'm one of the lawyers on the call, this is considered legal information. It's not legal advice. So if you need legal advice, we do recommend you turn to your counsel. With that, today we're going to run through some reporting issues that have come into play because of the CCPA, some authorized agent information for those of you that are trying to respond to privacy requests, Mark's story hour, which we will not give him an entire hour, but that's what it'll feel like. He'll share some of the ins and outs of how to actually make your privacy program work when you're responding to requests, and then we'll handle some Q&A. So with that, the first thing, reporting under the CCPA is still really unclear, but one thing that has happened that customers of SixFifty will be familiar with through our updates, but others may or may not have heard about in the past, is that there's a new data broker requirement in California. So we talk about this as part of the CCPA. The requirement, the law relies on definitions from the CCPA, but really technically it's its own rule. So essentially, the first question you have to ask yourself, of course, is, am I a data broker? And so this slide here will help you sort of work through that on a case-by-case basis. Essentially, if you are covered by the CCPA, so if you meet one of the CCPA thresholds, which is, you have $25 million in worldwide revenue, you have 50,000 California consumers' data, or starting in 2023, that number will go up to 100,000. Or you make at least 50% of your revenue from selling California consumer personal information. So that's a really brief way of describing who's covered by the CCPA. So if you are covered, that's probably why you're on this webinar. But also to be a data broker, it's covered by the CCPA Plus. And the plus is that you knowingly collect and sell personal information to third parties. So keep in mind the CCPA has a very broad definition of the word sell, and the data broker rule relies on that CCPA definition. So essentially, if you have the personal information of any California consumers, and you share that with a third party who's not your service provider, and so a service provider under the CCPA is somebody who you have a contract with that essentially limits them from doing anything with the consumer data you share with them other than performing services on your behalf. So if you're knowingly collecting and selling information to third parties, so you're sharing it with somebody who's not a vendor, and Okay, so here's the and. You lack a direct relationship with the individuals, the California individuals whose data you're dealing in. And so this is where the data broker rule gets, I'll just say, confusing. We don't have a lot of information here yet. The CCPA also uses this phrase, lacks a direct relationship, but also does not define it. So we don't really have anything from California law to help us know, well, which individuals do you have a quote unquote direct relationship with? What we do have is we have a similar law out of Vermont that did give descriptive examples of what constitutes a direct relationship. So in Vermont, they said, if somebody's a customer, a client, a subscriber, a user of your service, a registered user on your platform, an employee, a contractor, an agent of your company, an investor in your company, or a donor if you're a nonprofit organization. Um, all of those would be people that have a direct relationship with your organization. So we can't say that we can rely on Vermont law. It might be helpful though, in terms of if you're trying to think about, I'm not sure, our relationships are a little bit nuanced. But for the most part, just think through like, am I selling information that maybe I didn't get from the consumer? So if I'm a data broker, it probably means that I'm an organization that collects information from multiple places. Maybe I scrape it off of the internet, so I'm not getting it direct from that consumer. They're not my clients. And then I am selling it to another party. That would make me a data broker. There are some situations though where you may otherwise look like a data broker where you can claim an exemption. And those are, for example, like a credit reporting agency. They gather a lot of information that they're gathering from people who are not the consumers themselves, and then they resell it, but they're covered by FCRA. And so they're exempt from this data broker rule. And same thing with financial institutions covered by GLBA and entities covered by the Insurance Information and Privacy Protection Act. Keep in mind though, even if you are one of those organizations, you're only exempt from this data broker rule insofar as what you're doing is covered by that governing law. So, if you're a financial institution covered by GLBA, but you also have a lot of data that's not covered by GLBA that you're potentially selling, you would be a data broker insofar as that data set is concerned. So again, this is pretty new. It just went into effect in January. If you are a data broker, of course, the follow-up question is, okay, I think I'm a data broker. What do I have to do? And the answer to that is that you have to register with the Attorney General of California. We're going to send out the slide deck. The link is there for you. If you're like, oh my gosh, I need to register, you can click on that word register on the slide and it'll take you to their website. If you were supposed to register and you failed to, there's a $100 per day fine for every day you failed to register. So if you're in that category, I recommend you go register now before any more days pass. There's a $400 fee. The money all goes into the data broker registry to help, run compliance with all of these issues. And when you register, you need to tell them, the name of your company, your, internet, email, physical addresses, and some additional information about what you're doing with data, what your data collection practices are. That last piece, which feels like it should be the hardest piece, is actually the most vague. They're just sort of like other information you want to tell us. And so it's pretty vague in terms of what they're asking for. We anticipate that it will become a lot more detailed as the new California Privacy Protection Agency comes online and they start to really, fill out the rules and clarify what they want with things like, what's my description as a data broker. So with that, before I move on, are there any questions? I can't see the chat. Any questions on this so far, Austin, that we should address?
So the one that's come in is if you're working with a vendor or other third party to buy a customer list or contacts list, how is that covered here?
Yeah, so under the rules, if you're a purchaser of the information, it doesn't automatically make you a data broker. So somebody else that is selling you that information, that's the data broker. However, if you take the information from that list and you do something with it, like you sell the information, that could turn you into a data broker. So again, it depends on what you're doing with the information once you purchase it. But the seller is the one who has to register. Thanks, Austin. Okay, so right now the reporting requirements are sort of around, data brokers. You've got to register, you've got to fill out that short information sheet. But something that we are anticipating that we want to help companies start to think about ahead of time is that we have some future reporting requirements that are going to come online in 2023 when the CPRA goes into effect. So for those who aren't familiar, California Consumer Privacy Act, which we currently have, the CCPA, is in full effect, but it's been amended by a ballot measure that passed last year in California. That ballot measure is the CPRA. And so those rules go into effect on January 1st, 2023. And one of the updates that it will make is that it will require companies that are engaging in high risk data processing to perform an annual cybersecurity audit and also to submit a risk assessment to the California Privacy Protection Agency. That's a new data protection agency that the CPRA also created, and which they're starting to staff out now. They've got their board appointed. So we don't know exactly what that risk assessment will look like. Again, because the CPRA says, this new agency needs to give us additional rulemaking so that we know what that should look like. But what we do know about it is that it will require you to identify if any of your processing involves sensitive personal information. So, you have personal information generally, and then you have particularly sensitive personal information, which includes things like your protected class information. So, somebody's gender identity, somebody's, well, it's not protected class information, but also particularly sensitive information like a social security number, somebody's genetic information, so health information. So, those types of data processing, if you're engaging in that, you're definitely going to have to perform this type of audit. And then you'll also have to do some cost benefit analysis where you say, these are the benefits of the processing to us as the organization. These are the benefits to the consumer and maybe to other stakeholders and even the public potentially, depending on what kind of processing you're engaging in. But then you also have to weigh that against the risks to the consumer, to their rights, to their privacy. So those are the things that will be showing up in those reporting requirements. But again, like in terms of putting flesh on the bones for what you'll actually have to turn in if you're engaging in that, we don't have a lot of information. In the privacy space, most of us are anticipating that it will look somewhat like the requirements that you see in Europe under the GDPR and under the new Virginia privacy law, which has given a lot more information about what reporting will look like in Virginia. So we're sort of anticipating seeing the new rulemaking body in California sort of mimicking those requirements. Okay, well, I guess I should say, are there any other questions on this section before I move on, Austin?
So the only question was how to define high-risk companies or high-risk information, that kind of thing.
Yeah, and the rules actually haven't defined it for us yet. That's one of the things that we're anticipating that the new Privacy Protection Agency will tell us. But again, like sort of in the space, we're anticipating that it will be similar to what we see in Europe and Virginia. And so if you're engaging in processing of sensitive information, but also potentially if you're engaging in mass profiling, so if you're collecting the information of large numbers of individuals, if you're running any sort of AI on the information that you're collecting, things like that are considered high risk in other jurisdictions. And so we would anticipate that we'll see a similar type of rule set being put into place in California. Okay, so that is the rulemaking section that we wanted to get through today. And that is going to bring me to authorized agents. So again, for those who may not be as familiar with the CCPA, in the CCPA, consumers are allowed to submit different types of privacy requests. So they can say, I want to know what information your company has about me. I want you to delete my information. I want to opt out of the sale of my information. And with each of those types of requests, you go through a process where you have to have some sort of identity verification where you determine, yes, before I delete all this information, I've verified that this individual is the person in question. So one of the things though that the CCPA allows is for those requests to come in through authorized agents, so through a third party other than the individual. So you can have an authorized agent submitting, any of these types of requests. One thing to note is just under the rules of the CCPA, under the regulation that goes along with the law, for requests to opt out of sale, if you have user-enabled privacy controls that turn off or on different options in your system, so like you could opt out through a user-enabled control like on the browser, that's not considered an authorized agent request. So just keep in mind that little subcategory doesn't fall into what we're talking about here. So with that, when you receive a request through an authorized agent, first of all, there's some proof that's required. So you're not, you shouldn't automatically respond to every request that comes in. You should verify that this person or organization is truly the authorized agent. And to do that, you can ask for proof. So that proof would be a writing signed by the consumer, authorizing the individual or the business as their agent. You can require that agent to submit the proof to you, the company. But even then, you still can make the choice if you would like to. You can still require that the consumer directly confirm either their permission or their own identity with you. So for example, some of the organizations that we work with at SixFifty deal in financial data. So say you're an accounting firm and you receive a request that says, please delete my data, and it comes in through an authorized agent. And you deal in that person's financial information, so it's a pretty big deal for you to go in and delete that, and you're governed by a lot of rules. So typically the financial customers that we work with would say, well, we need a copy of the permission form where they say this person or this organization's my agent. But then they would directly contact the individual and they would say, we need you to verify, first of all, that you're you. So they go through whatever verification questions their organization asks. And then they would say, and have you authorized so-and-so as your agent? So again, like not every company will go to that extra step of directly confirming with the consumer, but depending on the type of data you're dealing in and the types of requests that you're dealing in, that may be a step that you need to take because of the sensitivity of the data that you handle. That being said, if you have an actual power of attorney that is subject to California's probate code, you don't have to ask for those extra things because somebody with a valid power of attorney automatically has the right to do these things without going through the extra steps. So that would be sort of an exception to the proof case. And so then just sort of a few other things for you to keep in mind. If it's a natural person, if it's an actual person that's saying like, hi, I'm Joe, I'm submitting this request for Sam. Joe is a natural person. But if it's an organization and I say, hey, I'm ABC Company and I'm submitting this request for Sam, you have to make sure the ABC Company is actually registered with the Secretary of State. So it has to be a registered organization. And if you are an organization who's acting as an authorized agent, you're supposed to have, security measures and practices put in place to protect the sensitive information of anybody who you're acting as an agent for. And that agent is also prohibited legally from using personal information for any purpose other than fulfilling the consumer's request. So if I'm acting as an agent and I say, hey, Sam wants a report of all the information you have about him, and I then take that information and use it for my own purposes because I'm creating my own customer database and I'm reselling that information, huge violation. So those organizations, we're starting to see more organizations coming online that are acting as authorized agents. And just keep in mind, they are governed by a number of rules. So if you make the determination that the agent is a true agent and you're going to fulfill the request and maybe hand off data to that agent, what happens to it at that point, if there's a breach on the agent side, that's not your concern because they are governed by a different set of rules and they'll have to answer for that separately. So, Mark, did you have a question? Sorry.
No, sorry about that.
Okay, yeah, great. So that's just sort of the authorized agent piece. And Austin and I thought we'd talk through a couple of potential examples with everybody. because we started to see a number of these coming in and companies trying to figure out what's the best way to respond to things. Austin, would you like to take the first one?
Yeah, absolutely. So for generic requests, getting just an email saying I want my personal data, especially when it doesn't come through your designated CCPA request intake processes, whether an interactive web form, toll-free number you set up, etc., and is from a third-party service, not the individual. You, under the law, you don't have to respond to that, treat that as, a full request since it didn't come through the procedures you've laid out. However, just as a general matter, you may want to forward it to whoever handles your process, as long as it doesn't look like it's spurious or something, just so that, if it is a real request from someone, they don't complain to the Attorney General. And even if you're completely in the right, you might not want that scrutiny. If it's not a big deal and it doesn't happen often, especially, you might want to handle it like that. Under the law, it's not a valid request, really. So it comes down more to pragmatics there.
Yeah, I think that's a really good point on the pragmatic side. I've seen a few of our customers receive like a number of these. So if you're on the high end of requests and you're getting a lot of these sort of, I shouldn't use the word spam requests, but sort of like mass requests almost, it could be a good idea for you to templatize, and Mark will talk about templates in a second. Templatize a response that's like, hey, like, this isn't how we receive requests. If you want to submit an actual request, please do this. And then you give them the instructions that are the same as the ones in your privacy notice for how to submit the request. And maybe include the section about authorized agent so that if it looks like it is coming from a third party, you've got that taken care of. But yeah, for sure, you're not required to respond to those. It's a little different than the GDPR, right? Because in the GDPR, no matter where the request gets sent, they could give it to the customer service desk in your St. Louis office and say like, hi, I'm in your brick and mortar store and I want to know what information you have about me. And under the GDPR, if we were in Europe, not St. Louis, you'd have to figure that out, like, right? That customer service person, front desk person would have to figure that out. But California, it's much more like you can have designated methods and you can say no if they don't come through the designated methods. And that sort of takes us, the second one that we have, this household request. So say it did come in through a designated method. I have a portal online where I receive privacy requests. It came through the portal, but then I'm looking at it and I realize like, oh, we'll use Joe and Sam again. Here's Joe asking for an information report about Sam. And I can see like Joe's filled out information that shows me they're members of the same household, but Sam is not Joe. I've gotten a request for the wrong person. I can't give a report about a household member without getting permission from that second person. So maybe they share a joint account, right? Maybe I'm a streaming service and they're part of the same household, but Joe is asking about Sam's profile. Not sufficient, right? But if I want to give like a full household report, I can get permission from both household members if it's just Joe and Sam. So that's something important to keep an eye out for, like especially if you have like shared accounts because of the type of platform, the type of service you're offering, unless they have like a joint access dashboard, which some services do provide, and you allow them to submit requests through that dashboard, unless you already operate that way. If you operate with like nuanced, individualized data, then you should not give the data for the second person to the first person. Does that make sense? Keeping in mind, of course, minors are a different story. If you have minors, there's the parental authority side of things. And if you're dealing in minors data, that is really one of the areas where we recommend that you would talk to counsel before making sort of generalized decisions about how to handle things, because minors data is extra sensitive and has a lot of extra rules around it. Austin, do you want to do the third one?
Yeah, absolutely. So if you receive a deletion request that again comes through the proper channels from someone who says they're an authorized agent for a particular consumer, but have not submitted any documentation, the law allows you to ask for documentation from the authorized agent that they have gotten written permission from the consumer to submit that request on their behalf. And if you want, and especially, again, pragmatically, if you're a financial organization or have particularly sensitive information that people would want access to more than just transiently, you might want to ask the individual to confirm as well. So you can do both of those things. So it depends on, how sensitive the information is, how much you're worried about accidentally deleting something that was not actually submitted by a consumer. So you have the options there.
Thanks, Austin. Are there any questions on this section before we move on to operations with Mark?
Looks like a few just came in right now. One is a kind of an ever-present question regarding sale of data or whether or not you sell data. And that is, if there's an exchange of data under a contract but no exchange of money, is that still selling? So that's one that we hear quite often, actually.
That's a classic CCPA question. So the way that the CCPA defines the word sell is it's the selling, renting, release, disclosure, dissemination, transfer, pretty much anything of personal information to a third party for monetary or other valuable consideration. And that's where, in this example that you gave, it sounds like it would be considered a sale because data itself can be valuable consideration. So if you give company A your data set and company A gives you their data set, that would be considered a sale because you receive consideration in exchange. So yeah, California's definition is a lot more broad than some of the other jurisdictions that we've seen.
Another question, I might take the first question up there about how to address requests that are not from California consumers. There's also one from Jenny that says, what other forms of verification are valid and reliable?
I'm gonna guess this is going back to the authorized agent question.
I think
probably.
so.
So I would say, well, let me maybe start earlier before authorized agent actually. So anytime that you're servicing a privacy request, you have to make a decision about what you're going to ask as your verification questions. So for example, the opt-out of sale has some special rules around it that are like, it needs to be just as easy as opting into sale, right? So typically companies will say like, we're not going to require verification on these. We're just going to accept them all and process them all because there's rules around it that say like, these don't have to be verified the same way that other requests have to be verified. But deletion and actual reports of information, that's much more sensitive. And so based on what your company is collecting and what you're going to do once you receive a request and how it could impact individuals, you may need to make your verification steps like higher level, depending again on what you have about individuals. So for example, if you are just like, oh, we're mostly marketing, we have people's email addresses, we have like a couple of points of information about things they've bought before, and that's pretty much it. Not very sensitive. So you might say like, well, we're going to require that you input your email address and then we'll shoot you a message and all you have to do is click on a button to verify that you really do have access to that email. Done. But then the example that we were giving with the financial institution, that's really sensitive information. It's a lot of information traditionally if you're somebody's financial institution. So instead of just asking a few verification questions like, what's your email address? What's your physical address? You might ask like, you might have a secret question that you have attached to their account and they have to answer the secret question correctly. Or you might have, an additional piece of less public information that about your clients that you could use as your verification. So again, you don't want to collect new sensitive information, and you should never ask for like like if you're saying like fill out this form and we'll delete your information, never ask for something in that form, like say their social security number. There's a special regulation that says don't ask for that, it's too sensitive. So again, like what you ask for depends on what you collect. Don't ask for new things because then that doesn't help you verify them anyway. And you may decide to implement that additional in-person part of verification if you have really sensitive data. The vast majority of companies don't need to do that, but some of our customers, I know we have some customers on the webinar today who are financial institutions that are, you know, doing things like that because of the nature of their work.
Marie, this is a really good question, and it's becoming more and more common with these third-party requesters. But this individual is asking, how do you address a request from a company not based in California that submits a request via the designated method, but then they try to make you or require you to go to their site and portal to then comply with the request?
Yeah, so that does go a step beyond what has been described in the CCPA. And so we've talked with a lot of people in the industry who feel really comfortable saying like, no, we're not going to do that. And there's nothing in the CCPA that says we have to. Again, like depending on the number of requests you receive, maybe you feel comfortable doing that. But I would, in those situations, say that the vast majority of companies right now are choosing to instead send a response that says, you know, that's not how we process these. We can only process them according to our designated methods. Please, you know, go to our portal or, you know, call this number and we will work, you know, work through that designated method.
Yep, that's what I'm seeing the majority of clients do as well. Yeah, and it's frustrating because you start to have them try to tell you how to run your requests and how to manage your requests, where you have a process built or should have a process built that could throw you completely out of your compliance that you're trying to put into place. So
yeah.
yeah.
And I would say, like, if you're a larger organization receiving a lot of requests and you start to see a number of these, like it would be you know, a great idea to talk with your counsel about it so that your decision about how to handle these would be like your decision-making process would be privileged between you and your counsel. But yes, as a general rule, the industry right now is saying like, we're not required to do that.
Great. Let's see, based on what Marie said, is the use of Facebook lookalike audiences a sale of data?
Ooh, that's a great question. The answer is probably not. Right, this is my lawyer answer. It's like it
Yeah.
might be, but it probably isn't. So when you create a lookalike audience on Facebook, so long as you're like using generic information to create the lookalike the lookalike audience, you're fine. But sometimes you can create lookalike audiences on Facebook and other social media platforms by doing things like sharing email addresses. And then the social media platform will use that email address to build out like a really intense lookalike audience. That is a situation where you're probably selling data. But if you've genericized information, you say, no, all I want is an audience that, you know, shares these common factors, and you're not actually matching them to real individuals who are, you know, in your, you know, your current customer base or something like that, then you're okay. But sometimes people build lookalike audiences by using real information. And in that situation, you could actually, yes, be crossing the line into selling information.
Great. Looks like we're caught up on questions, but if you have any questions at all, you're welcome to keep chatting them in, or specifically in the Q&A. And then Austin will get to those, typing those, or we can answer them live towards the end. Anything else, Marie, or should I get going on this section?
I was ready to mute myself. You can get going, Mark.
Ah, lovely, thank you. This slide I created just as a reminder, because we do have a lot of our clients and a lot of others that are reaching out and asking about what we need to do with employees and employee data. The fortunate thing, well, whatever you consider fortunate, is that we still don't have to process requests for employees. There are a couple of requirements regarding notice to the employees. So employees have there's a document that we have that provides a notice to the employees regarding what categories of personal information we have as a company, the business or commercial purpose for which the information is being collected. And that's now part of the CPRA. That's been pushed out, giving them the ability to actually make requests, employees. So that is still exempt. You do not have to fulfill any type of request of an employee requesting that their data be deleted, for example. But after January of 2023, the CPRA will also expand to allow notice or have you provide notice of whether information is going to be sold or shared, as well as the length and time that that business intends to retain that information. So that
Mark.
was just a, yes, please, Marie.
Sorry, if you don't mind, I thought I'd just mention here really quickly, with this, it's important to note, because of COVID, you may need to update your notice to your employees. So for example, if you're running a health screener and you created your notice before you were doing that, you're now collecting new information from them that's not included in your notice. So make sure that if you've changed your processes this year because of things like COVID, that you've updated the information that's in your notice based on those new procedures.
That's a great point, Marie. If you are a client of ours, that document is called the Limited Privacy Notice, and it's easily updatable anytime you need to update that. So, Marie, if you don't mind hitting the slide button. Okay. I don't know if anybody remembers or has ever heard of this opt-out icon. There's been a couple of iterations of this icon, and this was put out by the Attorney General's office, and it was done to create a recognizable and uniform icon. Now, that's what the icon is. They say that you need to use this icon, or that you can use this icon, that it should be a similar size to other icons or any other buttons on your website. It is currently not required, and it does not replace the "Do not sell my personal information" link that you need to put on the main web page or the main site. So this is now available. It's at this link at the bottom of the screen. You are welcome to use it. They want to see it used more often in the future to a uniform. Everybody knows that's what that link or icon is meant to be. That you have the ability to opt out of the sale of your personal information. So again, those who can use it or should be using it or are encouraged to use it, businesses that engage in selling personal information with all of the nuances of selling information, which is very broad, as you're all aware. So that opt-out icon is now available, and it is currently not, from what I'm understanding, required, but is available to you. So you've received a CCPA request. First, congratulations. Second, I'm very sorry that this has happened to you. However, if you are an advocate for the CCPA and you are very happy to fulfill these requests, awesome. But how do we respond to these requests? How do we allow people to respond to these requests? There are a few different ways, but really it comes down to getting an internal process created, making sure that you're providing the correct means by which people can make a request, and then keeping your messaging to the consumer and the fulfillment, making sure that you have a pattern to follow, and also hopefully some templates that you can follow. So on the left-hand side, we have one of our forms that we have that many companies are putting on their site. It's right to know your information. This might, we have all different types on this webinar. We have those that are just nascent and getting this updated and putting it into place. We have those that have been doing it since day one. But it's a right to know your personal information, right to know the categories, so either the details of the categories of that data, a request to delete that personal information if you can, and also a "do not sell my personal information." Interestingly, we do see a lot of companies that do place the "do not sell my personal information" link and make that available even though they are not currently selling data. The reason they're doing that is they feel like they are making their clients feel more, I guess it's more pleasing to their clients to know that they have the ability to make a request. And then we have an automated response if you're using our tool that automatically says, hey, we don't sell your data, but we'll place you on a list in case we ever start to for some reason in the future. So when you receive a request, there are a few different types, obviously, and each of these types may have different requirements. An example is a "do not sell" has a 15-day due date. Each request has to be responded to within 10 days, and then fulfillment for the majority of these is a 45-day window. If it takes longer than 45 days, you have the option to extend that by another 45 for a total of 90. But that's only if you have a valid reason for that. Then the messaging to the consumer. Processing the request, this is where it gets very confusing for many of our clients. The reason for this is we don't see everything that you have on the inside and all the different tools and systems you have in place. No company can actually do that fully. And so there are different users, different managers of those different systems that you need to work with. And we try to provide a platform where you can identify all of those users and then create workflows to say, hey, when this type of request comes in, we need it to go to this person and this person. When they fulfill their requirement, either if it's a deletion or to surface data, then they mark it as complete and execute it. If you don't have a system in place to do this, we recommend you just take as best notes you can on a spreadsheet or however you choose to do this, as long as all of the data is being tracked. When did you receive the request? When did you initially respond? When did the information actually get either deleted or surfaced? And then responding, when did you fulfill that request? So making sure you're tracking all of that is key. For users of our tool, you don't have to do most of that tracking, it's already done. But if you don't have a system in place, it's highly recommended that you make sure you identify all of the steps that have been taken in case you're ever, heaven forbid, audited in the future. Let's go ahead and go to the next screen. So receiving requests, there are a few different ways that an individual can make a request. A request to know, you can submit it via an email address or a toll-free number. The toll-free number is really interesting. That is still a requirement for organizations that are not exclusively online. Also, the toll-free number, what I've seen with our current clients, is never used, almost never used. In fact, I think I've only seen maybe 2 or 3 ever receive a phone call via the toll-free number to make a request. A request to delete, any 2 methods need to be provided. A do not sell is either an interactive form plus either a second method. Best combination we've seen is if you need to have a toll-free number, meaning you do have brick and mortar or you have a location and you're online, an interactive form plus the toll-free number is the best combo that we've seen to help fulfill those requirements. Okay. One more. Now, responding to these requests. This can be very confusing. We see that Jane Goodall has made a request. She doesn't want this organization, Mark's Fine Foods, to have her information anymore and is asking to delete this data. So what do we do then? Can we delete the data? Is it data that we need to fulfill an obligation or to actually perform our current contract with that person? Is it data that we have that we're just marketing to Jane for some reason? We need to make those determinations, and what we recommend is creating personas. So if Jane is a current client, a former client, a prospect, any number of different persona types that you're creating, you can see what Jane is. Jane, for example, was never a client, you could say. If Jane was never a client, then we have this set of data on that person. And then you can execute that deletion request, leveraging the tool and also leveraging any of the internal resources you have with the different systems you may have to delete that data from. If you know what that person is, maybe it is an actual client, but you can't delete that data, then there are a series of forms or canned responses that you can send. And we have all the legal justifications for why we cannot delete data, why we can maybe partially only delete some of the data, or fulfilling the request altogether and saying, yes, we have deleted it, or just say no altogether. It really comes down to what data do you have, why do you have that data, and what is so are there other regulations managing that data, or that it falls onto a retention requirement for you to maintain that data? When you get any of these requests, what we recommend is, again, make sure that you're documenting when everything comes in and what steps you need to take for that particular type of request. If it's a request for data, if it's a request for categories, a deletion or an opt-out, a do not sell, make sure that all of that is being documented every step of the way. Now, then it's the determination of what can be surfaced. Do we have their social security number? We're not going to surface that. Can we delete their data? If they're maybe a financial client, there's a chance we can't delete most of their data. And then creating a uniform template based on the different types of responses you'll see for the persona types is going to be key. That way, you know, and you have uniformity of all of the requests that you've received, how you've responded to those individuals, and you're doing it the same way for each type. That way you can have one, uniformity in your process, but it also is going to help expedite some of these requests as you move forward. So creating uniform templates based on your specific company. Some of the examples we do see are, requests for deletion where we can't delete anything. And so we have an automated response many times for a deletion request if it's a certain type of organization where we automatically tell them we can't delete your data, and we give the legal reason in one of our templates here. So maybe it's to complete an ongoing transaction or to fulfill our requirements or GLBA, whatever that requirement may be. My recommendation, though, is that anybody who's using our tool, it's always good to have these templates created and create a persona based around those. For those that are not with us or not our clients, same thing applies. Uniformity is going to help you in a myriad of ways, internally and externally. And if you're ever audited, you'll have a great trail of adherence to this particular, the CCPA specifically. And you'll be able to better identify the needs of any of these requests and any of these individuals moving forward. So that is a very brief overview, obviously, of responding to these requests. They vary so greatly that I can't give very specific examples, but you're welcome to reach out anytime and we can help you as best we can.
Yeah,
Any questions there? Sorry, Marie, go ahead.
While we wait for the questions to come in, I was just going to say, like, one thing that's really important as you create those personas and the associated templates is to remember to customize those templates. Like if you're coming in and you're taking a 650 template that, gives the examples of all the potential reasons that you could claim an exemption for a deletion request, they're not all going to apply to you. So, the screenshot that Mark's showing is showing an example of all of the technical exemptions that you could claim under the CCPA. But, if I'm not actually using information for, non-client persona to complete an ongoing transaction, I shouldn't have that in my template. I need to remove it because that template needs to be customized to that persona. So I think sometimes organizations are like, oh yeah, we have templates, we're set, but they forget that they're supposed to customize each template to each persona that they've created as they've gone through that process that Mark was just discussing. So that's just something to keep in mind, to double check yourself on as you're going through that process.
Yeah, and the more you can automate, the better. If there are specific rules that you have or different systems you have internally, it's always helpful to, depending on the volume you're getting of requests. We have some clients that are getting one request a month. We have some that are getting hundreds and hundreds a month. So depending on your needs, it could be a benefit for you to look at what systems could be automated, what systems could be a master system of record, for example, where if you delete data out of one system, it deletes it out of all systems. These are areas that I would work with your IT group or your technology team to see if there are those potential options for you that might make your lives easier moving forward. One little hiccup I have seen, just as a helpful hint, hopefully, is there are systems that exist where if data is not deleted in sequence, meaning if it's not deleted last, then it will repopulate other systems with that data as a backup. So again, it is helpful to work with your technology teams to make sure that things are being done correctly.
Yeah, and I think that's like, I don't see anything in the Q&A, so I think we'll wrap up unless something comes in the next few minutes here. But I think that's a great point, Mark, just for companies to think about generally. The CCPA doesn't require that you take a privacy approach to all of your data processing. The GDPR does if you're over in Europe. And in 2023, the CPRA, which comes into effect for California, does require that you start using a data minimization approach. So, start thinking about it now, because a holistic privacy program will be a lot easier for you and your colleagues to administer than one that's just like responsive to individual new requirements. So, as we're moving towards 2023, even though currently you don't have to do some of these things yet, knowing that you're about to have to do them can help inform decisions that you make about how to use data generally. And, similarly, like working across teams, like Mark is talking about, that becomes really important because you can educate other teams about how they should and shouldn't be using data, so that later you don't have a compliance problem crop up after the fact where you've been doing something inappropriately for a while because, the teams weren't talking to each other. And mapping your data can be really helpful there. Again, California doesn't require that you data map, but if you do that, it will help you be much more efficient in how you create those personas Mark's talking about. It will help you be really sure that you're giving all the proper notices because you'll know what you're doing with the data. And it will also help you ensure that you're not keeping data you don't need, because why take the risk, right? Like if you have data that's just sitting there that's really not being used, it's not helping optimize a customer experience, it's not really doing anything for the company except making us feel good, because we like having data. It makes me feel good to know that I could find out anything I need to know about anybody in my system, but do I really need to? So thinking about those decisions from that holistic perspective will make your privacy program in the end a lot easier to oversee.
That's a great point, Marie. In fact, when we do data mapping exercises with our clients, they take that as a time to start reevaluating why they're collecting certain data points and what systems they're using. And they start to eliminate many of those because many of them become superfluous at that point. So, yeah, data hygiene, always a good thing, right?
Yep. Okay, well, I think that we've taken care of everything that came in through the Q&A. So we are going to sign off. Again, if you're looking for a recording, that will come out later, along with a list of the questions that were answered during the presentation today. And thank you so much for your attendance.